Not Miss Hall. I don't think everything else from Miss Hall. We have other.
So how long do we have to?
Well, I was trying to reschedule it, remember? So I just got off the phone when y'all made me come back to court, so I don't know. Like I had to leave at 2:30. And so I was trying to reschedule it, but I had to get off the phone to come and take this plea. So what do y'all want me to do?
We can discuss Mr. Baines real quick if you want to log off or you want to be here for Mr. Baines.
Yeah, we can do whatever y'all want to do. I'm here, ready.
Okay, now we can get.
We have probation stuff to do.
And then we got probation, there's a couple of things up here, and just, we do have to give this all, you know, the same stuff. And let me go find Mr. Zingo and get this file.
Okay, so are we gonna do Baines and then y'all gonna do probation stuff and then we're gonna finish my pleas or what?
Yes, ma'am, that'll be fine.
Okay.
Your Honor, in regard to Mr. Baines, he's online. I was just getting there.
Do you want to know?
Yeah.
I need to know what it is.
Position 48.
Okay. And we're taking a step down, y'all, and y'all step out and talk.
Why you just had that?
Yes. Christopher Baines, he's online, Your Honor. His current charges are aggravated assault and aggravated battery. He was offered the adult diversion program sometime back. Since that time, Mr. Baines has been removed from the program. And he feels at this time, his request is to ask the court to dismiss the case. I attempted to explain there's an offer that's been made, a misdemeanor offer that's been made. I did explain that to Mr. Baines, as well as the judicial process, which would require at this point, if he didn't want to enter or accept a plea to the misdemeanor and enter a plea of guilty, that the next steps would be trial. However, he believes that the court should dismiss the case. And so that's just a little bit of background. And then I'm going to just turn it over to Mr. Baines to add anything in addition that he'd like.
Good afternoon, Your Honor.
Raise your hand.
He's my here.
Firm testimony about getting this tree, raise your hand. You swear firm testimony about getting this tree, so tree, nothing but tree.
Yes.
All right, let's go ahead. You speak up a little bit, because the court has to take it back.
Okay, Your Honor. The prosecution had gave me a deal into which I was basically required to complete a certain amount of steps in order to basically have the cases dismissed as far as the deferral program and pretrial. Now, given that to understand, I completed everything I could complete on my end. The issue came about when a part of the deal was for me to contact the prosecutor within 48 hours of signing the deal, which I did immediately. I did not get a response. Once I contacted the prosecutor, she told me that I had to go back and talk to my attorney. My attorney told me I had to go back to her, so they gave me a runaround. Now, I completed everything else as far as the community service, staying. I actually, because of this case, I moved 2,000 miles away from the alleged victim in order to keep away from any problems. I have been working hard, basically trying to get me a job and trying to basically become a professional. When for 4 months, I have been contacting the DA and my attorney in order for them basically to get me into the classes. I did not get any response. I didn't get no enrollment or for none of that. And the incentive of the deal is that if I complete those steps within 6 months, I'll be allowed to basically get the case dismissed early. It got to the 4th month, basically 4th month and 5 days, and I still didn't get no response. Now, during that time, I had experienced homelessness, I experienced starvation, and I experienced the death of my grandmother a week prior to that. When I emailed her the letter, I had not eaten in 3 days. So I was under extreme duress. And I'm steady contacting everybody just to try to see if I can get this last little step of the process done. By the time it was the 4th month, one of those courses takes 10 weeks, which is 2.5 months, which actually would have eliminated me from the 6 months incentive that I was basically trying to achieve. And with that situation, I contacted both of the attorney and the DA, and let them know my displeasure for them basically dragging their feet and basically giving me the runaround the whole time when I'm adamantly trying to get this job done. And because apparently I offended them, which I showed the email. I was professional the whole time. I just voiced my displeasure for the just lack of cooperation. The DA deemed me basically basically deemed me not basically a good candidate for the program. And then she said basically you got to take it back to the judge. Now, me personally, I felt like I was given a faulty deal, and I felt like that for this situation, uh, a special performance order needs to be enacted because I can in order to basically get this done. I have not contacted the witnesses. I actually currently I just accepted an offer from Northwestern Mutual brokerage firm to become a finance manager. And on February 19th, I passed the license and disability exam on my first try, which not too many people even passed on the first try. But I've been gainfully basically doing the best I can from my efforts in order to get this done. And I didn't get no cooperation or help from the other side. And which really upset me that I'm still going through this process and I'm still living in my car. And I was basically trying to get employed so I can basically get on my feet. I had nothing to do with this situation. Well, I had no fault in this situation because I kept contacting both sides in order for them to please help me get this done. And nobody wanted to help me. And I felt like that was a faulty deal, and I felt like it was an unconscionable deal. And I felt like the court should at least hear me on that and understand where I'm coming from. And I feel like the DA should honor their portion of the deal and basically dismiss both charges.
That's all. That's all.
Yes, Your Honor. I have no idea what the defendant is referring to when he says that he's spoken with me. Multiple times. I haven't had one conversation with this defendant. Even when I gave the offer to his attorney when we sent him into diversion. So I'm not sure who he spoke with at my office, but he certainly did not speak with me. Your Honor, just to give you some background, the defendant was charged with aggravated assault and aggravated battery. Because there was a victim in this case that did not want to see him go to jail, we worked back and forth, me and defense counsel, and we finally came up to this offer of him doing a diversion program for 6 months. I don't know why he failed to do that. I listened to what he said. It sounded like he said he didn't do community service. He was trying to contact us and all other type of things. But there is a list of things he should have done. And if those were completed, when I got notification of that, as you know, Your Honor, I would have dismissed the case. I have not to this day gotten any notification that he's completed anything. Maybe Ms. Carter can fill me in on if he had issues entering the program.
Yeah.
But as far as Mr. Baines, if you can give me a moment, as far as I know, Your Honor, he was entered into the program. I don't know, or at least I'm not aware of any issues that he was having. If that's the case, we could have dealt with that. But I have spoken with his attorney multiple times. I even, because he got kicked out, offered a misdemeanor instead. And now he just wants a dismissal. And so that's not something we're inclined to do. We do believe that he did commit the crimes that he committed. We didn't have to give him diversion. I do not have to dismiss the cases or reduce them to a misdemeanor. So at this point, Your Honor, if he doesn't want to work the case out, the case can move forward to trial, and the state will say, we're ready.
Your Honor,
And just to clarify, he was given the adult diversion program. Part of entering the adult diversion program is that you attend an orientation. And at that orientation, they explain some classes that they offer, as well as explain where you can and can't do the community service, things like that. When he entered the program, initially, we were waiting for the judicial hold to go through. That judicial hold went through for him to start the program. At that time, it was during the cyber attack, so there was nothing going out. So he was contacting me. I was then contacting the state to say, hey, he still needs an orientation date. Let me know when you can get an orientation date. This kind of went back and forth. Every time he contacted me, I would contact them. He also had, it's Ramona Toole, I think she's a deputy a deputy ADA or DA, I'm not sure. But he also had her contact information. He sent an email to myself and them that they didn't find to be appropriate. And at that time, they deemed that we're not going to accept you into the program. This is kind of a gift. This is, that you are allowed to enter the program. And based on this email that you sent, we're going to remove you from the program. So he was not, at that point, never able to finish the program because he wasn't able to attend the orientation or the classes that they offer. So while he may have done some community service, he did not complete the entire program.
Your Honor, I'd like to speak. I have emails, documentation, and timestamp for that from the addresses I was given to email these ladies. I can send it to you right now. I contact both these ladies. I have documentation showing that I did complete the community service. I completed basically the supervision. I completed everything else except the part that was required. I was never given the opportunity to enroll in those classes, even though I contacted her. And let me say this: the security hack happened on January 27th. I signed the deal on January 24th. That was 24 hours. The expiration of that 48-hour time span was 24 hours before the January 27th. So that means the 25th and 26th, I did not get any information. I can submit the emails when I contacted whoever's Anthony Hall.
Right.
When I contacted them, I have.
Wait. Put your mute. I'm put your mute because I'm gonna talk. I'm not dismissing the case, so you can continue to communicate with Ms. Carter. She can continue to communicate with the state, but I guess you're gonna put this ready for trial, Ms. Carter.
If that's what Mr. Baines wants, if he want, if we are going to formally reject the misdemeanor offer, our next step would be trial. The only thing I would ask of the court, if we could possibly specially set that date, so Mr. Trial knows to avail himself to the state of Georgia.
Your Honor, I have documentation that I did my part. Is what I'm saying. I have documentation.
I'm not going to dismiss the charge.
No, I said, can they have you honor that? I just need to understand as far as how can you just offer somebody a deal and not do your part, and I did everything to complete my part.
All right, Mr. Banks, put you on mute again. I'm not going to dismiss the charge. I have a full room here of people. Well, can we special set it for a date? You have to give him notice, or we have enough time to give him notice in that trial calendar. And you can continue to talk with Ms. Carter, and she can continue to talk to Ms. Hall. If that's possible. And then you don't get date certain for this.
How much time is it? I don't wanna say the railroad.
How long will it take you to get here, Mr. Baines?
Take yourself off mute, Mr. Banks. Just answer how long it will take you to get here.
I don't have a specific time span because of this process, I've been given a denial.
Mr. Banks.
It's just
Wherever you're at, like a 3-hour drive, a 2-hour drive, a 4-hour drive. It's not, you don't know.
Your Honor, I live in California. It's a 32-hour drive.
Okay, well, you either plane or 32 hours. You gotta fly or you gotta drive.
I can't call it right now because I don't have a vehicle that can drive 32 hours.
I guess you'll fly, okay.
So do you need 30 days to avail yourself for a trial date? Because your next court date, we will be going to trial.
I'm saying as far as apparently it's not gonna get dismissed. Is there some way we can still work out a deal?
You need
And if
30
not-
days.
Yes, we can.
We can still
me and
work
your
out-
attorney will speak about that and we'll talk about that. Yes, we can. Yes.
Yeah, I can, Jess, you can mute for now, Mr. Baines, and I'll give you a call. And I think that it's just a 12-month probated sentence and I think an anger management course. Is that acceptable, Ms. Hall?
Yes.
Okay, I'm gonna go over the plea colloquy with him real quick and then we can come back on and we can enter the plea.
Okay.
No. I'm about to get off. So y'all just let me know what you're gonna do.
No, she's gonna get back on later.
You're gonna get back on later?
She's
Yeah.
got things to do.
I'll call him and then by the time you get back, we'll be ready.
Okay.
Okay. Thank you, Ms. Hall.
Thank you so much. All right, now what else?
You're welcome.
You ready for the month?
Yeah.
Okay.
DeMonte McNabb,
Hang back.
he's position number 5 on the trial calendar.
He's the
I would-
Codes.
Correct.
We're
All right,
ready for Mr. Baines.
Mr. Baines, can you please raise your right hand?
I'm not ready.
And if I could just ask Mr. Baines one quick question. Did you want to use your first offender today? You do have the benefit of using that before the court today, and that would, upon your completion of the probation, it will seal your record. But if you use it, you lose it. So you won't be able to use it. If you have a felony in your future, you're not going to have that available to you.
What happened if I don't, what's gonna happen to my record if I don't conceal it? And will I be able to get it expunged?
I mean, you can still go through the expungement process. Yeah.
Mhm.
Would that, if I seal it through the expungement process, would it count as my first offender?
No.
Then I'm not gonna use my first offender.
Okay. We're ready to go forward. Sorry.
Which Baines is this?
Mr. Baines, can you,
This is Christopher
Christopher
Baines.
Baines?
Uh-huh.
yes, position 48.
You got a criminal history already, Bostic?
No,
Not you, Bostic. Your name's not Bostic.
Your name's not Bostic.
I
Mr.
I
Baines,
didn't-
two cycles.
I didn't hear that.
Stop.
I didn't hear the
Go
last
ahead,
name.
That's okay, sir. Just one prior arrest for disorderly conduct in the OIG.
Okay. Thank you, Bostic. Go
What's the
ahead.
last thing she said? I'm sorry.
Disorderly conduct.
Illinois.
One prior arrest, disorderly conduct. and what?
Illinois.
Illinois.
Okay.
You ready?
Go ahead, Ms. Holt.
Mr. Baines, can you please raise your right hand? Do you swear or affirm the testimony you give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes,
You may lower your hand. Please state your true, correct, and legal name.
Christopher Lewis Baines.
Did you say Lewis?
Yes,
Good. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
no, I'm not.
Is there any medication that you normally take that you have not taken today?
No,
How old are you and how far have you gone in school?
I'm 33 and I completed 3 years of college.
Are you able to read, write, and understand the English language?
I am.
Do you understand that you've been charged with aggravated assault and aggravated battery being reduced by the state to aggravated assault being no process by the state, aggravated battery being reduced to battery family violence?
Correct.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yeah, but hold on. As far as the battery family violence, I thought it was just battery.
It's battery family violence.
Okay.
Do you want to move forward with the plea?
Yes.
Okay. Do you understand that you've been charged with battery family violence?
Yes.
Okay. Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
Yeah, because I didn't know that it was gonna be family violence. I thought it was just gonna be a battery. I didn't know.
Or not?
And can we drop the family
No.
violence just for battery?
No, it's either battery family violence, or we're gonna move forward on aggravated assault, aggravated battery. It's your decision, Mr. Baines.
I just have a question as far as why wasn't that discussed in the deal? I was told it was battery.
I'm not sure why, but this is that I'm making the offer of battery family violence, and it's your choice if you want to move forward or not.
We put it on the record before.
It's been on the record, right?
When we first talked about it before we went to break.
Mhm.
Oh, yeah.
I didn't hear the family violence part.
Okay, Mr. Baines, would you like to move forward or not?
Yes.
Do you understand that you've been charged with battery family violence?
Yes.
Okay. Do you need more time to discuss this case with your attorney?
No.
I'm sorry?
Mr. Baines.
No.
Okay. Are you satisfied with her services?
Yes.
Mr. Baines, you gotta speak up.
I said yes.
All right, you're turning away from the microphone, so it's hard to hear.
Can you hear me
Counsel,
now?
Counsel, do you waive from reading of the indictment?
Yes.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
So wait.
Mr. Baines, have you been arrested on these charges?
Yes, I would. Wait, not previously, but currently.
Okay. I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No.
Has your attorney advised you of the maximum sentence of 12 months to serve on the charge that you're pleading to?
Yes.
Do you understand this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 12 months probation, special condition that you complete an anger management course or program, but the court does not have to accept that recommendation. The court can sentence you to the max, which is the 12 months to serve. Do you understand?
Can you repeat that?
Do you understand that the offer is 12 months to serve and you have to complete an anger management program?
I was understand that once I complete the anger management program.
Remember, I told you that I'd have to ask the judge for that?
I didn't.
Well, do you understand now, Mr. Baines, that the offer from the state is 12 months probation and that you have to complete an anger management course?
Yes, it was.
Do you understand that the judge can then not accept the recommendation from the state or from your attorney and can sentence you to the max, which is 12 months to serve? Do you understand that?
Yes.
Okay. Do you understand this is a guilty plea, which is permanently reported on your criminal history?
Yes.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would, and this is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that by pleading guilty, do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
I understand, but I'm sorry, but I do have to talk to my lawyer about this because I'm be honest with you. It seems like
We got other police.
I'm sorry. I'm sorry.
Okay, well, that's fine. Your Honor, can we just reset this case and,
It's ready for trial.
we're done with the
It's
record.
ready for trial.
Okay.
And get a trial notice, sir.
April the 14th, he needs to be here.
April 14th, you need to be here at the courthouse, ready for trial.
Okay.
Thank you, sir.
And there will be no plea.